Ladies and gentlemen, it's my task as one of the editors to do the formal thanks to our speakers today. But before I do that, I'd like to take a small indulgence. As an editor to a book, particularly as a rather junior person compared to the other contributors of the book, one gets to submit a chapter themselves and pass it off as if it were as eminent as their chapters. So here I go, I get to speak to my chapter with just as much vigour as the previous speakers. I'll be very brief. What I wanted to point out was that this debate, there is actually two debates occurring here across Australia in regards to a Bill of Rights at the moment. One debate is the question, should we have a Bill of Rights? And that's a policy question, and it goes to what sort of judiciary and what role do we want our judges to play in the future. The second debate that's occurring is, can we have a Bill of Rights? Is it a constitutional function for judges to implement a Bill of Rights? So, whilst most of our book addresses the first question, and I think quite adequately makes the significant case why a Bill of Rights is a bad thing for Australia, there is this other bit of the debate that needs to be made on the public record, and that is that it would be against the Australian Constitution to enact a federal statutory Bill of Rights. I'm not going to go into all the details and all the cases, but I'm simply going to state that for at least the last 60 or 70 years, the High Court of Australia has consistently held that the federal judiciary cannot do two things. It cannot accept legislative or executive power except where incidental to judicial power, and it cannot give advisory opinions. And there's a long flow of case law that supports those two propositions. What a federal statutory Bill of Rights seeks to do is give judges the ability to effectively legislate from the bench. The function of legislating, that is, making laws, is inconsistent with the judicial function. Judges exercise the judicial function and the judicial function alone broadly. When we give judges the responsibility of legislating from the bench, we rip up 60 or 70 years' worth of High Court precedent, and we create a situation where, as Senator Brandis quite adequately said before, we are ripping up the separation of powers. So there are two debates going on here. There is the broader debate, should we do it? But there's a smaller debate, which some of the national broadsheets have been following, and that is, can we do it? And very tellingly, a couple of the major proponents or chartists, Michael McHugh and Sir Gerard Brennan, are on the public record as expressing their view that a federal Bill of Rights would be a breach of the Constitution. So we need to start exploring this issue greatly. It's a very technical issue, even more technical than whether we want a statutory Bill of Rights. And that's why in my chapter I've set out the arguments why it would be a breach of the Constitution, but who am I to make those arguments? What we need is an eminent lawyer's view on whether it would be a breach of the Constitution. And it is incumbent upon the federal government that if it goes down this track, that it makes the case that a federal Bill of Rights would be consistent with the Constitution. And that is why I've called on at the end of my chapter that the now Solicitor General's view should be made public so that the Parliament knows that what it's looking at doing is constitutional, and more importantly, the Australian people know that their government is proposing legislation which is consistent with the Commonwealth Constitution. Anyway, that's my chapter. I also wanted to just quickly mention, as a young editor, one finds oneself late at night Googling the name of the book in one's own name to find reference to the book. I came across a speech of the Chief Justice of the High Court, Robert French, a speech that he gave a few weeks ago. You've heard here tonight reference made to the expression unelected judges. This is what the Chief Justice had to say a few weeks ago. There is, quote, "There is, however, one term which has been deployed in the debate which provides an opportunity for reflecting upon the role of the nation's judiciary. That is the term unelected judges. A subtext can be associated with the repeated invocation of the term unelected judges. It is what might be called in contemporary political discourse a kind of dog whistle signal suggesting a lack of democratic legitimacy in what judges do." I respectfully suggest that the Chief Justice is incorrect in his description of the expression unelected judges. We, on this side of the debate, use the expression as a term of respect, not denigration. By judges not being elected, they avoid the downsides that politicians have to put up with. They avoid the interference into their lives. They avoid the minute attention to their political choices that they make themselves. When we use the expression unelected judges, it is because we like judges so much that we want to protect them from the winds of political change and the odium that sometimes attaches to the politicians. No disrespect to the politician in the room here tonight. We need to protect the function of judges, and that is to protect them against becoming just another politician. And that is why we need to oppose a statutory Bill of Rights. Ladies and gentlemen, thank you very much for coming along here tonight. I'd particularly like to thank the Chief Justice of Queensland, who has done us a great honour by writing in the book and lending us his digs here this evening. Thank you very much, Chief Justice. I'd also particularly like to thank the two contributors who have flown here from interstate, General Molden and Dr. Bennett, for coming in today. And thank you very much to all the distinguished contributors to the book. Ladies and gentlemen, thank you very much. And once again, you can buy your books over there.